A last will and testament is a legal document in which you name who you want to manage your estate after you pass away and how you want your assets distributed after you pass away. One of the most common misconceptions about a will is that it has to go through probate after you pass away. People do not realize that. A will is just a piece of paper until it's admitted to the probate court and the judge stamps a seal of approval on it and says, yes, this is a valid will, everything in it was signed properly, it's got the proper statutory form, and the judge issues what's called letters testamentary or letters of administration, depending on the state, and gives the person named in the will the power to go forward and do what the will says. But there is a probate action required in that process. So people always want to know, well, how much does probate cost? It just depends. It depends on what assets there are. It depends if your family's feuding. It depends on if you have real estate or not, how large the estate is. And the court costs typically aren't that high, but the attorney's fees are where it gets expensive. Lawyers in Jackson County are paid around $300 an hour to do probate work. So it's just kind of a question mark in your plan as far as what that's going to cost and how long it's going to take. The probate proceeding, the way it happens when you want to have a will admitted is you have to hire an attorney. And you have to petition the court. Sometimes there's a hearing to see if the person should be appointed or not that's named in the will. All of the heirs are notified of the proceeding so they could show up in court and cause problems. But once the person named in the will is appointed, that puts the plan into action, but the court supervises the opening of the estate, sometimes more steps within the estate, and sometimes the entire estate, depending on the situation, the size of the estate, the parties, whether we have minors. There's just lots of variables that can change. The advantages of doing a will is that you take all the argument out of everything. You've decided who's going to serve as personal representative or executor. You've decided who gets what assets instead of having to follow the state statutes, which dictate who gets what out of your estate if you haven't specified in a will. Another advantage that's huge is for planning for minors. We can do testamentary trust, which is discussed in another video here on the website. You can waive bond, which is an expensive insurance policy that's required whenever you have a probate estate if it's not waived. And you can authorize simpler forms of probate within a will so that the judge isn't supervising every single step along the way. And then finally, the biggest advantage of a will if you have minor children is you get to name a guardian in your will. It's the only legal way to do it. It's the only legal way for you to nominate who you want to raise your kids, and that is your voice to a judge in the future who decides who gets guardianship over your children after you pass. So that's absolutely critical to have a will if you have minor children.